matter of Haytop Country Park and Amber Valley Borough Council.
Yes.
My Lords, I appear in this matter for Haytop Country Park Limited. My learned friends, Mr. Kimberlin and Miss Anastine, appear for the Borough Council in that case. A variety of documents have been handed up and a number have been sort of discussed in email over the last couple of days.
Yes, can we just check about those, where we are and what we have now been provided with? Yes.
My Lord, what the court should have had initially would be core and supplementary bundles.
Yes.
And an authorities bundle.
Yes.
What should have reached the court yesterday were a A3 hard copy of page 97 of the core bundle, which is showing which is an RPS plan.
Wait a minute, has that been added to our?
I think
when you say an A3, you're talking about this thing?
it would be that size, but that's a document which
It's a different one.
It's a different document.
So what are you talking about?
It is an A3
Of which page?
Of page 97
Of the supplementary.
of the core bundle.
Cool.
That should have reached the court, yes, in hard copy.
Did you mean reached by email?
Should have been handed by hard copy as well, my lord.
Okay, we certainly got an email which had the 2022 licence decision, plus I think a clearer version of page 97.
Yeah.
But not in colour.
Right, okay.
Mine is.
No,
No.
well, it is in the bundle.
Oh, okay.
But I asked for a clearer
Larger
copy of
version,
that, a
yeah.
larger version of it, so
Yeah.
you could pick out all the numbers
Yeah.
and so on.
I see.
Yeah.
So that you have sent, but we haven't got it here.
That was sent to the court in hard copy yesterday by my clerks. Sounds like it's not.
No, hasn't reached us.
We can
Okay,
make arrangements on that.
thank you.
And as my lord said, with that would have been a copy of the original site licence, so the 2022 site licence, which was issued by the council. It sounds as if that was electronically yesterday.
Yes, I don't think. Anybody have that?
Not.
Have you got the licence? I think we can get this copied.
No.
Yeah, let's get a copy, please.
I'm grateful, thank you. So, my lords, those are the documents which would have gone in yesterday.
Right.
I'll
yes.
come to any questions on authorities in a moment. What I've passed up
Yes.
are 4 documents, and those relate to the site licence as it would have been amended, first of all, by the first tier tribunal's decision, and then secondly by the upper tribunal's decision.
Yes.
Those are
I'm going to copy those.
Which is which, please?
my lord, the version which is as on the front page, if my lords you can see the track changes, version which is dated the 6th of July 2023
Yes.
is the site licence as it would be to give effect to the first tier tribunal decision.
I can't actually see the date.
It should, my lord, be on the front page.
Yeah.
Is it bottom left?
1, 2, 3.
What? Can you just show me the document you're looking at, the front of it? Yeah, this one.
Yes, my lord.
That one.
So there's
Yeah,
the track
Page is there.
Well, I've
Track
got,
changes
on
in-
my copy says the 22nd of August 2024.
We've got
my
two.
lord, there's
Another one.
there should be
Well,
2.
both of them say that.
Okay, then you got two of the same.
I've
got
got
two
two
saying
saying
sorry.
6 July 23.
Oh, there we go. That's what's happened.
23.
Give me.
Ah.
I'll sort of.
Thank you.
Right. So the first
I think we're
tier
probably okay.
tribunal, the effect is
So 6th of July 2023.
That's FTT.
That's FTT, my lords. And
Do we have a plan that goes with that?
Yes, my lord. The plan which goes with that is it's one of the A3.
My Lord Justice Nugee will have 2 copies of that.
I've got plans showing units after Upper Tribunal
Same
decision.
here.
I haven't got one showing FTT.
Right.
I've got 3.
Okay, there we go. Thank you.
It's the best document.
Right, okay.
Right. Okay.
So this is the effect of the FTT
Effectively
decision.
the FTT decision.
Got it?
And what has been done is to mark in green the plots which are approved by the FTT.
And this, because their decision refers to a plan. I mean, is this the plan they approved, or something that's been created by somebody else?
It's been created. What was in front of the FTT would have been, in terms of the plots, would have been the document at page 97.
Yeah.
Which is all the proposed
I see.
plots by the appellants.
So this is the 18.
This is the 18, my lord.
Thank you.
And can I just ask one other question? The whole site, is this showing of the whole site? Because I can see the red line. I mean, I can't quite work out. Or is this just part of it?
It's part of the overall caravan site. It is the part in which caravans
Okay.
are proposed to be sited. So
And the trees that are shown are existing trees.
that's correct, my lord. The trees, my lord, can see the sort of centre points of those and the serrated edges. Those are existing trees.
And what are all the black dots?
The black dots are the proposed tree replacement notice locations.
It's not a proposed, it's an actual tree replacement notice,
Yeah.
isn't it? Which has been upheld.
It's been upheld with
It's enforcing against the unlawful cutting down of trees, presumably in those locations.
yes, my lord. The reason I refer to proposed is that what we have here are the tree replacement locations which are in the tree replacement notice as issued,
Right.
but before the appeal against the tree replacement notice had been determined.
Okay. Did that change the positions?
Not materially. What I mean by that, my lord,
Okay.
is that there were some changes
Yeah.
to locations and to species and so
This
on.
gives us the broad picture.
But yes, my lord. But what they were sort of trees under power lines and things like that.
Yeah.
What they don't do is alter the position about conflict between proposed caravan site locations and replacement
Can I
trees.
translate that to see if I've understood?
Yes, my lord.
So, the finally approved tree replacement notice has black dots in some respects in slightly different positions, but those differences don't affect the impact of the tree replacement notice on where you can put hard standings.
Correct, my lord.
Good.
So the court will have the effect of the first tier tribunal.
So, in other words,
So
just to make sure I really grasp that, those differences wouldn't affect the plan you've helpfully given us, the UTT decision plan with its 6.
correct, my lord.
That still properly reflects the constraints of the finally approved tree replacement.
Yes.
That's very
Yeah.
And the tree replacement plan is not subject to any further challenge.
No, it's not, my lord. But as a court will appreciate, there was a series of applications, appeals, notices going on at the same time. So the court has the first tier tribunal decision in terms of the effect of it. I should emphasise on these aren't the site licence documents issued following the decisions, because that hasn't happened. But what they show is the substance, and both parties are content.
That's very helpful. It shows how they would look to reflect the decision.
Indeed, my lord.
Because obviously there's a little bit of confusion with the FTT decision. This way, hopefully we won't get confused.
No, my lord.
At least I'm speaking for myself. And
my lord, I hope that's helpful.
Can I just ask you another question about the key? I can see the dot says tree position something.
Yeah.
And the other one is what are the words?
Seems to say possible.
Proposed or possible caravan
Caravan
position
with
surface. My lord, friends,
hard stand, is it? Or no, it isn't, is it?
possible caravan position with number is the
Oh, with
language
number.
that's
Okay,
used.
thank you. Yes.
And what those show in the site diagram I've asked before is the ridge of a twin unit caravan. So that's a caravan that's produced by bolting two units together, and a little bit of hard surface around the caravan, as well as the caravan being on a hard surface.
Right,
It's
okay.
not that's done in a sort of diagrammatical form rather than
Yep, thank you.
precisely how they're
Yep, no,
constructed on
thank you
the
very much.
You don't have any photographs of the twin unit caravan.
Don't believe we've got any ground level, what when we say ground level photographs. There's a number of aerial images.
Yes.
And then the
aerial shots, I think, show the by a red line the perimeter of the site licence thing.
yes, my lord. Yeah.
Going back to my lord's question.
And we can also see the perimeter shown on the plan, which is with the 2022 site licence, which is the one
That
which is
came
being,
by
which is being
The one
copied
being
at the
copied.
moment.
Right, okay. And you've also given us the appellant's appeal skeleton argument to the Upper Tribunal for the purpose of the appeal to the Upper Tribunal. Yes? Oh no, wait a minute.
I think that's
No,
the.
what's this?
We will ask for a copy of. Just asked this morning for a hard copy of the appeal skeleton
Okay,
today.
yep, no, I see, I'm misreading it. Thank you.
The Upper Tribunal.
No, don't worry, that was me, I confused you. Is that all the documents that you asked for?
The plan of the Upper Tribunal decision shows the 6 plots which remain.
Yeah, I see that, yep.
Can I, just in terms of how those may be useful given we have the plans out, just to look at how the plots relate to the enforcement notice.
Right,
So if my lords have one of the big A3 plans to hand and turn up in the supplementary bundle,
yes,
page 22, that is the plan with the operational development enforcement. It's a document that starts at page 18. The plan is at page 22.
yes.
It's not, I apologise, totally clear on the map base.
Sorry, what are we looking for?
So we're looking at page 22.
Yes.
And my lord can see the sort of the red line.
Yes,
So it's land subject to the enforcement notice
yes,
on operational development. If my lord has to hand the present purpose, I suppose, the Upper Tribunal A3
Yes. Yeah.
decision,
yeah,
the larger red area is essentially the area bounded on the Upper Tribunal decision by, on the west side, the dark hatched roadway, and on the northeastern side, the dark hatched roadway where the court can see a little D. The enforcement notice is in the area between those two dark hatched roadways.
The tribunal, the Upper Tribunal, describes that long feature going northwards is an access road, isn't it?
Is it so?
An access road. The long
Yeah.
feature on the plan going northwards is an access road, and the tribunal says as you travel south, you come to a fork, and there's a southwestern road and the southeastern road, and that's the dark hatch areas we see on the.
Yes, it forks there. The enforcement notice area is leaving aside the road up to the entrance to the site, is essentially what's within those areas with this important point, my lords. If we look at the enforcement notice appeal decision, sorry, the Upper Tribunal appeal decision, and the green marked caravans, 3 of those are within the enforcement notice area, and those hard standings are subject to the notice. So that's the one in the middle to the right, which is plot 1. And then towards the bottom left of the plan, my lords will see 4 plots there. The upper 2, which are 24 on the left and 23 on the right, are within the enforcement notice area. And those were those 3 plots I've mentioned, 1, 23 and 24, were all included within the original, the 2022 site licence.
That was the question I was going to ask. So, insofar as the Upper Tribunal varied that notice, they added 3 additional ditches, but ones which are not in the enforcement notice area. The ones which are in the enforcement notice area are ones which, ironically, the council put into their original decision.
Yes, my lord.
So you got lucky. If the Upper Tribunal is...
well, there is that my lord draws attention to...
Well, you call it an inconsistency, but it actually stems from what the local authority did at the beginning.
Yes, so the point, my lord, is that whilst the Upper Tribunal decision rests on a perceived conflict between the site licence and the enforcement notice, the position both of the council in issuing the site licence and then the Upper Tribunal in its decision was to approve 3 existing plots which are inconsistent with the enforcement notice.
And I think you're saying inconsistent with their reasoning.
Yeah, yes, my lord.
But what if, for the sake of argument, hypothetically, their reasoning is unimpeachable in this court? What would be the outcome?
My lord, in that situation, well, my lord, the reasoning of irrationality, which is how it's put, my lord, could not be unimpeachable, as well as a judgment of discretion, and the fact that the authority had included 3 of those does entirely undermine that. If contrary to that, to answer directly my lord's question, the effect of the Upper Tribunal decision should have been that it was irrational to include any of the existing bases which were within the enforcement notice area within the site licence, then we would be, and the court would be dealing with a situation where there was planning permission for 60 and a site licence for 3.
Yeah.
In that situation, assuming that would be a legally tenable construction, so I'm assuming that my argument that that position is was wrongly reached by the tribunal is rejected. In that situation, the appropriate course on a site licence would in fact be to approve probably a larger number of caravan sites, but not specify the locations, and then leave that issue then to be sorted out to the extent that there remains dispute in the planning process. My lord, an
No,
outcome.
I don't understand that.
My lord, an outcome from the enforcement notice process, which not only leaves all the existing plots incapable of being having caravans and hard standing put on them in the future, would lead to a situation where the benefits of the planning permission were knocked out, and there would need to be another solution. The other solution,
if one came forward with a proposal which had 60 caravans of a size that you could fit on to the areas A to H. But if, on the other hand, you want to have caravans or twin units on much larger pitches, it may be difficult to square the circle.
well, my lord, in terms of the numbers, we were proposing, in terms of the plots we were identifying, were less than 60 to accommodate some of those issues. My lord, yeah, perhaps I'll come to those points.
Yes, okay. So that's finished with that document.
That's finished with that document, my lords, and what I hope that does is set out clearly what.
And we've now
in, what's
all
out and
got,
why.
I think, copies of the April 2022 site licence and another plan dated April 23.
Could I just whilst doing the housekeeping?
Yes, sir, my lord.
If I go back, for example, to the FTT decision, that set out the conditions as they amended. Has that been reflected in the agreed document that you produced?
It is, my lord.
Very
Yes.
grateful, thank
My
you.
lord.
Save time, thank you.
The point of dispute in terms of what then went to the Upper Tribunal were simply a question of numbers and plots, which ones.
Thank you.
So, my lords, I hope that's helpful in terms of
Thank
being
you.
clear as
Yes.
to what's what. Can I turn then, with perhaps the benefit of having covered some of that territory, to my submissions? And the court will appreciate that since the 1960s, the Haytop site has had planning permission and a caravan site licence for 60 caravans. Very unfortunately, and we do take some of the blame for this, but since we took over as owner, there have been a series of disputes. It's taken 4 years to get a site licence, and when issued, that was for 3 caravans.
Sorry to interrupt, just to follow the chronology. When you say there was a site licence for 60, is that the 1968?
That's the 1968 site licence, my lord.
Yeah, thank you. Which we've got in the bundle.
Which we have, yes, my lord. The first tier tribunal increased that number from 3 to 18, which is an outcome which we were prepared to live with, not necessarily what we sought.
Just to be clear about that, did the 18 include the 3 which were inconsistent with the enforcement notice?
Yes, my lord.
It suffers from the same point as you make in relation to the Upper Tribunal.
Well, it's the 3 which are inconsistent with the notice are in all 3 versions, my lords.
Yes.
And
I've got the point. Thank you.
the Upper Tribunal saw that the 18 was irrational, since they would give rise to.
Wait, sorry to.
That's all right.
Did you cross appeal against the FTT decision, or
We didn't, my lord. No.
sorry?
We took the view that we would work with the 18 and then
You
potentially
bank the 3.
well, my lord, bank the 18.
Yes, including the 3.
Of course, includes the 3, because that is for the reasons I'll go into, an appropriate approach. And then if we would seek to increase beyond the 18, we would need to come forward with plots which somewhat adjusted from what had been proposed, which wouldn't conflict with the trees. So we would have hoped in due course to increase the 18, but that would be a variation to be sought from the local authority in due course. Now, my lords, we then find ourselves, as the court has seen, in a position where we've got 6 caravan sites plot in the licence, having previously had 60. The factual background, I hope, is relatively clear from the chronology. What I would...
When you say you had 60, when you buy a site, the licence doesn't automatically transfer to you?
The licence continues in existence, but the licence, the occupier, which is the operator of the site, needs to have a site licence. So what would happen is either the licence would be transferred, and that would, in most circumstances, that requires the approval of the local authority, or a new site licence would be secured. So there was a site licence in existence.
What you said is we had a licence. Strictly speaking, I don't think you had a licence.
My lord's right that the site had a licence.
You bought the site.
We bought the site.
You did not get a new licence in your own name or a transfer of the existing licence, but you had an expectation that you could.
Yes, we would have. We had applied for a transfer, which was turned down in early August 2018. We then applied for a new licence in August 2018, and that is after that was rejected and went through the appeal process. Ultimately, that was the licence with the 3 caravans on it, which we got in 2022.
Thank you.
I mean, you had a permission and a site licence for 60 in the areas A to H, and those areas include some locations which are beyond the areas now, the pitches now approved by the FTT and the UT up in the northern part of the plan. So you haven't fully exploited your permission yet.
We haven't for...
Okay, and the other,
Yeah.
just to get the geography clear,
Yeah.
what the FTT did on the plan you've given us this morning is include some pitches which seem to be in the area of the green. Is that right?
In terms of the
Like pitches 8 to 10, for example.
No, my lord, the central area, if that's...
Sorry, I used the wrong term.
No, it's... the central area is an area which is bounded by look at the dark road on, if we're looking at the A3 plans, either of those, on the left-hand side, what's the light coloured roadway, and then
The internal roadway.
and that originally linked back in. So if my lords go, just perhaps pick up the overall.
I'm sorry to take up time. It's a short point that none of those green areas are in the, sorry, I forget what,
in the central area.
Yeah, which was protected by a condition on the 66 planning.
It is, my lord.
Okay.
And
Sorry to waste your time.
no, my lord's help. And none of the plots which we had put forward were within that central area. There's a little bit, occasionally a little bit of dispute, but never actually subject of any actions to whether or not the roadway infringes on that at all. But if I can perhaps just give the court the overall sort of context, which may help to pick up my lord's question about the northern parts. If the court goes in the supplementary one to the aerial photographs and there's a number we could pick from, but if we go to page 76, which is the position in the year 2000, so
Sorry, hold on, 76.
page 76 of the supplementary bond knowledge.
Yep.
So that's an aerial photograph from the year 2000.
Just sorry, the red line refers to the licensed site. Is that the 68 license or the 2022 license, or are they both the same?
That is, I think now the 2022
Okay, thank you.
license. The original planning permissions had been on a smaller area. But if the court sees the sort of the rough sort of green filled in D shape with the lighter area of roadways around it, my lords, that's the central area that's referred to. It's
Yes.
not actually shown on the there's no particular plan with the 66. We know with the 66 permission on that, but it was in existence. So that's the central area. The northern area, which my lord referred to, is the more heavily treed area, and the court can see some caravans and some other structures within that. That goes down the slope of the valley. The land slopes from the southwest to the northeast, and at the bottom, the court can see just beyond the red line. So the bottom of the valley, the top of the image, the court can see the River Derwent, and just beyond that, beyond the field, is the A6 road and the railway line. And essentially, to pick up another point of context, the World Heritage Site, designated in 2001, is at this point from the Derwent, the River Derwent, including the river, to and including the railway line. So the bottom of the valley, in essence, at this point. The management plan includes a buffer to the World Heritage Site, and that is, again, in very broad terms, it's the slopes of the valley.
On either side?
On either side. So we are within the buffer zone of the World Heritage Site, but not within the World Heritage Site itself. And to pick up my lord's question about the as not exploiting the northern
That was purely a legal point, not a planning merits point.
yeah, I appreciate but just to sort of understand that context, first of all, the court will see that as generally been and remains more heavily treed than the area where we're proposing, and also, as one perhaps can imagine, caravans and other structures, as you go down the slope towards the river, are more likely to be visible from within the World Heritage Site.
Because I'm just reminding myself, your helpful chronology tells us that the tree preservation order was made in 1978,
Yes, my lord.
after the 66 planning permission.
Yes, it was, and it's a woodland order in this respect.
Not individual specimen trees.
Not individual
A
specimens.
woodland.
It's a woodland order, and just to help rest my lord on that, a woodland order covers all trees, including those which are grown after the making of the order. Sorry, I think I apologize. I think I'm probably going to get that wrong. But can I come back and just check on that? I think I probably is about. So doesn't include everything subsequently.
It includes regeneration.
But it includes in essence.
Charles Miners built.
It's normally you'd have a degree of regeneration, and you would have a degree of management going with woodland order as well. That ultimately,
But
the
the short
expectation.
point is there's a dynamic there. Things will change over time.
Yes, my lord,
And
that's
you're
right.
telling us that your clients have respected the tree preservation order in that part of the site as things have turned out.
Well, there were some elements cut. There was some of the removal was
Oh yes.
there,
I
and that was
see why.
based on a mistaken belief that permitted development rights meant that trees could be removed. But
Okay, thank you.
well, I was turning back to the factual background. I hopefully take most of this very, very quickly. 1952, we had the planning permission for 30 residential caravans. They could be used permanently, they could be used on a holiday basis. That's at SB2. And those were trailer caravans, so capable of being towed by a private car. Site licence is granted.
I thought the 52 licence says that it was limited to seasonal use, not to be used as permanent residence.
No, my lord, the 52 planning permission that doesn't restrict the basis of the use.
I'm looking at page 5 of the supplemental bundle, condition 5.
That's the 60.
Oh, my, is that the 61?
That's the 66 planning permission.
52 one doesn't.
52 doesn't. That approves 30
I see.
for any caravan use.
But they have to be designed for drawing by private cars.
Yes, my lord. So
Yeah.
Site licence was then granted in 1961 in connection with that. As it's again a matter of background, which may be helpful, is that caravan site licensing, as we presently have it, was introduced by the Caravan Sites and Controlled Development Act 1960.
Was there any prior regime?
Prior to that, my lord, the Public Health Act 1936, section 269, requires a licence for what described as tents and movable dwellings. That remains the licensing regime for tents and movable dwellings, extent that's maybe possibly some chalets or effectively sheds. But for caravans, the 1936 Act provisions are replaced by the requirement for caravan site licence under the 1960 Act.
Was the scope of the licensing regime widened in 1960 for caravans in terms of what would be relevant? I mean, the Public Health Act sounds like it's dealing with sanitary matters, but
The Public Health Act provisions are firstly far more general. We can break up in these two. The other difficulty which had arisen was that there were quite a few caravan sites being set up post-war, some of which had become lawful by passage of time or had essentially not been well regulated by the planning process.
some of them would have been pre-1948 when modern plan control started.
Yes, so some of those would have had consent under the interim development
Oh, of course.
process. Some didn't have any, and quite a few of those which were post 1948 did not have consent, and some of those were lawful. So a regime was brought in 1960 to firstly require some of the existing sites to have a planning permission. We don't need to be concerned with that in this case, my lord, but also to bring in what essentially is the caravan site licence regime. There have been some changes. One relevant here is that the appeal on the licence and the conditions is no longer to the Magistrates' Court in England and Wales, just to the First Tier Tribunal.
So you're saying it was a new regime. It replaced the Public Health Act, but it was new.
It was new, yeah. In replacement.
Because it was thought that more extensive control was required.
In terms of spelling out what the conditions would be within section 5, we'll come to that, and my lord, we can provide a copy of the 1936 Act provision if that would be helpful, just to sort of understand it, to help the context.
So we've got to the site licence of 61.
So the site licence of 61, and the nature of that site licence, as with most, is it has conditions which are requiring physical works to be carried out, including, we went to page 10 of the site license of the supplementary bundle. That requires hard standing for caravans in condition 5, a variety of services to be provided. Condition 14, surface parking. Then the 1966 planning permission.
Sorry to interrupt. Could you just help, please? If we go back to page 3 of the supplemental bundle, there is a plan attached to the 1952 planning permission.
Yes, my lord.
Which seems to be similar to the plan attached to the 1966 planning permission. See, not exactly the same, but similar perhaps. See page 7. In very broad, simple terms, how does that shape relate to the plans you've been showing us related to the 2022 licence?
My lord, we tend in this case to refer to this as the shoe. If my lords appreciate the sort of the toe to the southwest and the heel and the back of the shoe to the northeast.
Is this pointing north, this plan?
It is pointing north, my lord.
And you can see the railway line, I think, in the northeast.
That's correct.
And the river, even just about.
Just about make out the river and the village of Whatstandwell to the northeast of the railway line, including it. Essentially, the front part of the shoe, so where you would be between your toes and where you would lace it up, is the enforcement notice area. And the rear part of the shoe is on the sort of the river side of that. That, for example, would include where we now have plot 22.
Okay.
In 1966, that is sort of extended down to the bank, which is page 7, extended down to the bank of the river. And there's a little difference. Essentially, thinking of the shoe analogy, where the ankle would be. So my lords, I hope that's helpful on the relationship. If we go then to the 1966 planning permission.
Yes.
And that starts at page 4 of the supplementary bundle, with conditions from page 5. That was an an extension of the existing caravan site from 30 to 60 caravans. And the conclusion of the planning inspector in dealing with the use enforcement notice at the same time as the operational development, the works enforcement notice, was the upshot of this permission was that those 60 caravans could be caravans of any anywhere within the statutory description. It wasn't limited to caravans which would be trailer type or towable by private cars. And the court may well have seen, particularly on motorways, large caravans would be actually transported on the back of flatbed lorries. And then once put into a location, they would tend not to move from that location. They're usually referred to colloquially as static caravans.
So if the 66 permission has that effect, given that it has that effect, effectively it supplants the 52 permission, doesn't it?
Yes, my lord, it does, because it's the 60. It's governing not simply the additional 30, but it
It's
governs
actually
all
governing
60.
that point as well in relation to the original 30.
Yes, my lord.
But condition 5 said it was seasonal use. Is that right?
Seasonal in respect of the additional 30.
Well,
can
not
that
in the light of what you've just said to the court.
Yes, if it authorises 60 caravans of any type, then why are not all the caravan? Because the 30 under the 1952 were limited to ones you could tow.
Yes, my lord, that's right.
The inspector you've just told us has said that this extension from 30 to 60 not only authorises an extra 30, but changes the nature of the 30 originally granted in 1952 from towable ones to static ones.
Yes, in terms of the size which are permitted.
But that must mean that the 60 caravans are now authorised by the 66 consent, because they're not authorised by the 52 consent, because that's limited to towable ones.
And what condition 5 is referring to as the occupation of the caravans authorised by this consent?
But that's what you said a moment ago.
Yeah.
But that authorised must mean, as my lord is suggesting to you, the 60.
It can't mean the extra 30, because if all it did was authorise an extra 30, the original 30 would still be limited to towable caravans, wouldn't it?
Yeah, my lord, because what it's approved refers to the caravans, and it's without any in this permission any restriction on what the caravans are. So the statutory meaning of caravans is how it would be approached. So in terms of what we understand by caravans in this context, condition 5 in respect of the occupation of the caravans authorised by this consent being a seasonal use is dealing with the additional 30.
Yes.
I don't understand it.
I need to avoid.
I mean, I admit this is all fairly unfamiliar territory to me, but on the basis of what you've told us, suppose there was a caravan on plot 1 which had been put up after the 1952 permission, which was a towable, and you want to change it along with all the other, so you have 60 static caravans in 1967. What authorises you to put a static caravan on plot 1? It's not the 1952 permission, it's the 1966 permission.
That's right, my lord.
Why is that not a caravan authorised by this consent? I don't understand.
Because what the permission is not seeking to do is to take away existing rights in terms of the ability to have caravans which are permanently occupied within the original 30. It's looking at an extension of the site, and the issue that this is not been.
Is this what the inspector decided, or is it not an issue before the inspector?
The issue, particularly in front of the inspector, was the size of the caravans that could be sited. It was not in dispute, and it's accepted by all parties, including actually being accepted in the 1968 site licence, that of the 60 caravans, 30 are seasonal, and 30 are permanent residential, or can be permanent residential. Obviously, don't have to be occupied in that manner, but they can be occupied in that form.
Well, I think my lord is asking a question about the planning position, not the 68 licence. So what happened in the enforcement notice appeal, if we can just...
The enforcement appeal, my lord, finds at page 25 of the supplementary bundles. And then there are, it's dealt with in fact by the law firm. So there are three matters in the appeal.
What happened on the use point?
On the use point, the appeal was allowed both in terms of Law 25 Appeal A, which is a certificate of lawful proposed use of development. We were putting forward and saying we can.
So that's paragraph.
That is then page 27, paragraph 4 allows that, and the certificate is, I apologise, certificate is not in
I think it'd be helpful to have it.
the bundle. We can find that.
For completeness.
Over lunch, my lord.
Thank you. Is it does 72 help?
Sorry, my lord.
Does 72 help? On page 39 and 71.
Yes, my lord. So that's a determination to go back to.
So does it imply what you were applying for was a certificate for 30 static caravans for permanent residential and 30 static for 12 months?
But for holiday use, yes.
That's, if when we get the certificate, that's what it's going to correlate to, is it?
Yes, my lord.
Thank you.
Yes. So to deal with my lord's question about condition 5 of the 66 permission and what's authorised, the issue was about the size of the caravans, but the inspectors issued a certificate under section 192 of Type and Planning Act, which is conclusive that there's that permanent and holiday split in terms of the use which may take place. If we turn back to the 1966 permission, the supplementary bundle, page 5. And then pick up within that, I think it's been referred to already, condition 2, which is the question of caravan standings and grouping of those. The position in practical terms of that, I'll come to some consequences in due course. Practical terms of that is that the attached plan referred to in condition 2 is lost. It's more or less the except a number of places, including the Upper Tribunal decision. That plan has been lost. It should be on the planning register, kept by the council. The original applicant should have had a copy as well. But that plan has been lost. There is a plan with the 1968 caravan site licence, and we will see that at page 17 of the supplementary bundle, which has groupings, although it doesn't certainly have the orientation that's referred to in condition 2. View was taken by the planning inspector on the appeal that what was in the 66 site layout plan would have been something rather similar to what then appears 2 years later in the 68 site licence, but nobody quite knows what that was. That
The group lettering references are the same, aren't they?
yes, in terms of groups from A to
A to H.
I will, yeah. Now that, if it is the 68 layout or something very similar to it, that never seems to have been complied with. By Lords, we have at the back of the supplementary bundle overlays of a layout plan from the time with, first of all, at page 98, what is a plan prepared by the previous site owners, originally in December 2012 and then amended subsequently 2013 and 2015, of where the caravans actually were, I think under the previous ownership. And the court can
Can you
see
give the page again?
page 98 of the supplementary
Thank you.
bundle, my lord.
I've got it.
No, that's
But what's the legal significance of this?
legal significance in terms of the 1966 planning permission is that the evidence, although I make it very clear, my lord, that this is not, because there's never actually been an allegation of breach of condition 2 and enforcement, it's never actually been ruled on as to this, is that the position on the ground was that if the 66 condition 2 layout reflects other layout plans from around that time, it wasn't complied with.
Yeah, you said that.
There was some
What's the legal significance?
the legal significance in planning terms would be that if there's an attempt to enforce the 66 site layout, that would have been breached for more than 10 years.
So you
instead
say
of
there
breach
might
of
be an
being-
immunity argument from enforcement.
Yeah,
But
so it would be
not been determined yet.
that's not been determined because it's never.
But that hasn't been the basis for the decisions in the FTT or the Upper Tribunal. So do we need to worry about it?
No, my lord, and
The focus of those decisions is on the effect of the enforcement notice decision, which is binding.
indeed, my lord,
I
whilst
think you've got enough to.
my lord, whilst there would be scope for an argument about the site licence layout in relation to the 1966 planning permission layout, that point was that issue was never part of either the council's consideration in issuing the 2022 site licence or the issues in front of the first tier tribunal or the upper tribunal.
Yes. Just looking at the time, I think we probably need to move on.
My lord,
Yes.
so my lord, the final point I want to pick up on the 66 planning permission is at page 5,
Yes.
condition 9, which is the reference to the central green
Yes,
area.
yes,
We then get the 1968 site licence, which starts at page 13.
yes,
The first of the 2 planning permissions been granted, have a variety of conditions starting at page 15, and just draw attention to 2 points on those. First of all, page 15, condition 4, which is requirement to be siting in the groups on the caravan site licence
yes,
layout. That's the point that becomes, in due course, fatal to Haytop's case on the enforcement notice, because the permitted development rights relating to a caravan site licence is for doing development which is required by conditions on the site licence. The site licence requires hard standings, roads and utilities and the like, but the planning inspector, and then upheld in the High Court, held that those works were not permitted development because the placing of the plots, hard standings, and then what goes with it were not in accordance with the 1968 layout, which is required by condition 4 on the 1968.
The condition you were relying upon was another one, wasn't it?
We were relying on, for example, condition 8, my lord, about
Yes, that's it.
hard standing.
But Miss Justice Mould, as he now is, said you had
Yeah.
to read that with 4.
Said it had to comply with the site licence conditions as a whole.
Yeah.
So, my lords, that's the reason why our operational development enforcement notice appeal failed. On was it lawful? Did we have permitted development rights?
yes.
So, my lord, that's everything what I was going to say on the 68 site licence. And that should, subject to any questions, of course, have got deal with what I need to take you through on the history. We get to the decisions. Turning to the enforcement notice, I then want to also look at how the enforcement notice regime works with future development. There's 2 aspects mentioned in the enforcement decision. The first one, which I've just covered, which is that because of the non-compliance with the 68 site licence layout plan, it wasn't permitted development. So the legal arguments failed. And for my Lord's notes, in the inspector's decision, paragraphs 101, 106 to 108, most helpful on that.
101 and then
106 to 108.
thank you.
That's supplementary bundle 44 and 45. And then the second point on the enforcement notice decision was that the inspector declined to grant planning permission for those works because of the planning impacts. And that is in particular within her decision, supplementary bundle 56, paragraph 169 to 172, and notes that the planning context had changed, that the heritage designations, which were a major part of the inspector's concerns, all arose following the 66 planning permission. So Old Wesley Hall, which is to the southwest and on higher ground, was listed in 1967. The conservation area, I don't know the date, but the conservation area regime was only brought in the 1967 legislation. The World Heritage Site was inscribed in 2001.
Matter of law, why does that matter?
Well, solely for this point, my lord, that what we are dealing with here in terms of the concerns of the first tier tribunal about the planning context and the site licence undermining the planning decision is that most of the, least of the planning issues are matters that have changed since the 66
Sorry, I know
permission
that.
was granted.
You said that, but I'm trying to understand why it matters
Why,
as a matter of law.
why it matters is this in the context of the Upper Tribunal finding the inclusion of various of the plots irrational as undermining the planning context. What the tribunal then ends up doing is enforcing or giving effect to a planning view which has arisen since the 66 permission was granted. Now, views on planning merits may well change, and it may be thought that a planning permission which was granted a long time ago wouldn't be granted now. It would be inappropriate to do so. But if an authority wants to get rid of the benefit of that planning permission, the 66 permission for 60 caravans, then it has to go through the process of terminating the permission with a discontinuance order under section 102 of the Town and Country Planning Act, which involves potentially a decision by the minister and involves compensation. What it can't do is use the caravan site licensing decision as a means of taking away the benefit of the 66 permission.
Are you submitting that the Upper Tribunal erred in law because it took into account an enforcement notice decision which was based on planning circumstances contemporaneous with that decision?
Yes, because what
You are.
because what the Upper
The
Tribunal
enforcement notice decision was only reached because of development which was carried out recently, not in the 1960s.
Yeah.
So I don't understand
Yeah.
your time machine point.
what the Upper Tribunal do, I'll come to take the court through that reasoning in due course. What the Upper Tribunal do is to apply the current view on the planning merits of development on this site to the site licensing decision. The effect of that, what they are doing is to apply a pure planning consideration point. What is the planning position? They're not, what the Tribunal failed to do was to ask what was appropriate in site licensing terms. Appreciate, my lord, that's sort of jumping through towards the end of my argument, but I hope it helps having the context and having the conclusion as we move through the submission.
Yes.
Now, if you have enforcement notice, the planning regime allows planning permission to be granted for, firstly, development which is in place, which is contrary to the enforcement notice, and that's section 180 of the Town and Country Planning Act, that the enforcement notice will cease to have effect if there's a later planning permission for the existing development which is inconsistent with that notice. And also, whilst an enforcement notice will have a continuing effect, that if you're required to take a building down, you take it down the notice, you then put another building up as a replacement that's still covered by the terms of the notice, and you don't have planning permission for it, then that would be contrary to legislation by reason of section 181. If planning permission is granted for future development, which would, the previous version of that was contrary to the notice, then the enforced notice doesn't act against that future development. And the enforced notice doesn't remove any permitted development rights which you might have. So even if, as here, what was done by putting the bases in and so on was a breach of planning control because of the breach of the 68 site license condition, it wasn't permitted development. In those circumstances, those bases could be either put down in the future if we did have permitted development rights by reason of a new site licence to do that. So to take the situation we have with the three which were included in the council site licence, so 1, 23, 24, all within the enforced notice area. The effect of the site licence requires hard standing to be put down, so the caravans are on a solid base. Permitted development rights therefore arise for the development, which needs planning permission, which is for those three bases. So putting those three bases down in the future would have planning permission, notwithstanding the enforcement notice requiring the removal of those bases that originally put in that place. Common ground that the practical effect is that it would, in public law terms, be irrational for the site owner to have to dig up the existing bases if there is a site licence which requires those bases to be put back down again, because all you're doing is the trouble and expense and environmental disturbance of digging something up and then it's all just going to get put back down again straight away. So it's common ground that if this site licence requires hard standing to be put down for particular bases, then there are the permitted development rights to do so, even if the enforcement notice had required those bases to be removed in the first place. And also common ground, in those circumstances, there's no point in digging up bases which are then immediately going to be allowed to be put back. So how the way the local authority has opened within the regime, within the legislation, to address any concerns they have on the planning merits of future development would be to withdraw the permitted development rights. And that can be done by an Article 4 directions, Article 4 of the General Permitted Development Order. The process in very abbreviated sense is the authority make an order and then have to decide whether or not to confirm it. In this case, they made an order, and we find the council report on that. I think we need to turn it up at SB 58, something like 58. And then in due course they cancelled that order before it had taken effect. And that's a report which is at SB 70. If a Article 4 direction has immediate effect or comes into effect in less than a year to remove permitted development rights, then compensation may be payable to an owner who then doesn't get planning permission on an application for what would otherwise have been PD. But if it comes into effect a year after it's made, then there's no compensation for the loss of the permitted development rights at that stage. So when we come to look at the rationality of the first tier tribunal decision and the concern expressed by the Upper Tribunal about undermining the planning position, the legislation has a mechanism available to it, which is not to deal with that issue, which is an Article 4 direction.
Sorry, this is all question begging as to what is the right approach when the site licence conditions are determined. I mean, if you're right about the area of law, certain things follow in terms of PD rights, perhaps. But that's what we need to focus on.
Yes, I'm going to turn to the site licence provisions now, and then that will then take us on to look at how it's dealt with.
Yes.
So the court turns up the authorities bundle. we have extracts from the Caravan Sites and Development Act starting at page 3. Page 3, section 1 is the requirement to have a site licence. Section 3 starts at page 6. And that's the requirement. It deals with the issue of site licenses. Section 3, subsection 3 requires there to be a planning permission in place. Section 4.
Planning permission includes the conditions here.
It does, my lord. That's the
Specifics provision, section 29(4), not in the bundle, which deals with that.
So section 3, subsection 4 requires a duty to issue a site licence if it's not for a relevant protected site. So a holiday, if an applicant is seeking a holiday site licence, then there's a duty to issue it. If it's for permanent residential, then there's a discretion to issue it, and there are some regulations which
So this
deal with
case,
management and so on.
this case was discretionary.
Discretionary because we were seeking permanent residential as part of that, in terms of that sort of half of the well, in terms of the numbers. So we were seeking up to 30 permanent residential. By subsection 6 at page 7. Sorry, just reading. Sorry, I apologise for reading a long bit. Leave that. So that's section 3. Section 5, which is the critical provision about site licence conditions, starts at page 10. 5.1 is the power to impose conditions in the interest of persons dwelling thereon in caravans, any other class of persons, or the public at large. Preamble to 5.1. And then, without prejudice of generality, there are a number of things that can be included in conditions, which include in A, when they may be stationed for habitations, when they may be occupied, or the total number of caravans. C, regulating the positions in which caravans are stationed. D, securing and taking of any steps for preserving or enhancing the amenity of the land, including the planting and replanting thereof with trees and bushes. That's a point that's ultimately relied by the first tier tribunal in taking their approach to the trees issues. Section 5D, which is on page 11, empowers the minister to specify model standards. And we have a copy of the relevant model standards at the back of the authorities bundle. I don't need particularly to turn up at the moment, but that starts, the note starts at page 3, 4, 5. And deals with matters like separation distances, various sort of services and utilities being provided, hard standings and the like. The normal approach in the model standards is not to require the layout to be approved by the local authority, but for the operator to, site licence holder, to provide the authority with a layout plan and update it as they change the layout. Model standards.
Just to notify, in other words.
So,
just to notify.
just to,
Not seek approval. Is that what you're saying?
yes, my lord, and that is,
That's the site licence regime, is that right?
yes, my lord, in terms of the standards, my lord will find the part of the model standards are referring to at page 351, which is at standard 1, little Roman 3, plan of the site shall be supplied to the local authority upon the application for a licence, and thereafter whenever there is a material change, boundaries or layout of the site, or at any other time on the demand of the local authority. So page 351 are the back of the authorities.
Yeah, I'm just trying to find that. Yes, got it. Thank you.
Yeah.
Thank you very much.
So it's the standards, and it's 1 little Roman 3A.
Yes.
So that's the model standard approach to layout, is to say the site license holder needs to say provide a copy of the layout, but not that the layout is one that's approved.
Well, all it says is when you apply, you have to include a layout plan. It doesn't actually say the local authority can't control it.
No, my lord, the standards are statutory guidance. They have to be taken into account. They're not. There's no prohibition on fixing layout, and my lord, that's a point which is apparent in section 5, subsection 1, which refers to control on the ability to control the position of the caravans.
Exactly.
In it, now, the right of appeal under section 7 against conditions, if they are unduly burdensome, which is the test to be applied by the first tier tribunal. It's established, I'll pick up a couple of the references, that the section 5 power is to be used for site licensing purposes, not to what are purely planning purposes, albeit that there is an overlap, that there may be matters which are both matters for planning and matters for caravan site licensing. And take the court in particular in the authorities bundle to the decision of the Court of Appeal in Esdell. And that concerns site license. Just to pick up one point in terms of the what was common ground as a matter of argument, is that the dispute was about a site license which limited the occupation to 24 caravans, and the caravan site operator was seeking 78 caravans on those. One point which was accepted in argument, if the court goes to page 159 of the authorities bundle, page 913, which is part of which is the report of the argument in the Court of Appeal.
Sorry, which page again?
Page 159 of the authorities bundle.
159.
159.
Yes, thank you.
And at the bottom of that page, of G, counsel for the local authority conceded as the second point, the authority must not use the site licensing powers to impose a condition or combination of conditions so restrictive as to nullify the planning permission and prevent the whole of the land from being used as a caravan site, and gave an example there that a reduction from 24 to 4 would be ultra vires. Now, in terms of what the court said, can I just pick up on a couple of the references? Page 171, Lord Denning, page 95 of the report, 171 the bundle. What Lord Denning says there is that question of what's a planning consideration. So for the planning process, what's a site consideration for section 5?
Give me the page again.
171 of the authorities.
Thank you very much. Got it. It's the last paragraph.
Leads to the last paragraph, but in due course helpful, my lord, just to look at the whole of that page.
Hold the page.
In due course, but it's that there is an overlap, and then at E to F, matters which could be taken into account in site licensing of social balance, overcrowding of schools, transport issues, impairing amenity of neighbours, matters which the court may be familiar very often arise in planning matters, could be legitimate site considerations, but in G, impact on the green belt was
When
not
it talks
a legitimate
about
consideration.
transport problems, those are off-site matters, aren't they?
Yes, my lord.
They could be described as pure planning considerations. But I suppose if you try and say, well, explain the Court of Appeal's decision there, you would say, well, there are on-site considerations as well.
It's a consequence of what's happening on site, and again, in terms of the overcrowding of schools.
If there's concern about access, a dangerous junction, something of that kind, or too much traffic going down a country lane, that's all off-site.
Yes, my lord, and it's
Or indeed the pressure put on local services in a village, it's all off-site.
yeah, my lord, it is.
So perhaps the analysis is that's an example of a pure planning consideration which permissibly can control the number of people who can live on the site.
It's an example of
Site licence.
it's an example of what's seen as a site license consideration on the basis it would fall within section 5.1 about the interests of the inhabitants of the site, neighbours, and of the expression of the general public. My lord, I think it is clear from the case law that what is accepted as being a site consideration is actually quite wide, and it goes beyond immediate questions of public health and amenity on the site itself, albeit that would be part of it in terms of having utilities and planting on the site and so on. So it is, the Court of Appeal level case law is that it is one. What it doesn't include, turning back to the extract from Esdell, there was greenbelt provisions, so the protection of the openness of the countryside, seen as a planning consideration, matter that's identified significance in the planning process.
So they're taking into account the fact that there is a planning commission and it's unconstrained, no limit as to number of caravans.
Yes, my lord. And what's the court in Esdell and would not accept would be the use of the site licensing process to undermine the planning permission which had been constrained, or in the sense to undo that.
So it has regard to the planning baseline.
It has some regard to what is approved and what those controls are. So, Ronald's absolutely right in those terms. I come on to some implications of that. What the authority can't do is use the site licensing process as a means of undoing a planning decision which it no longer likes. And that point was put very firmly by Lord Justice Harman in Esdell, which is at page 176 of the authorities bundle.
Page
176 of the authorities bundle, page 930 of the report. And at D to E, so the middle of the page, he's talking about section 5 and conditions, very wide powers to site licensing authority, including right to limit the number of caravans on the site. But I cannot think that the legislature could have intended in this way to let the licensing authority pull the chestnuts out of the fire for the planning authority by imposing without compensation conditions which the local authority might desire on planning grounds to impose, but would involve the latter in compensation. So the authority can't use the site licensing regime to go back on what has been approved by either sort of undoing that or really having the effect of putting in restrictions and conditions which it would have, if it now thinks about it, it would have wanted to do on the planning permission. There is a mechanism for undoing the planning permission.
I'm not sure I quite understand that. What this is referring to is saying if you want to do something on planning grounds, you can't use the site licensing regime for that purpose. But as throughout this decision, it's saying there can be an overlap.
Yes, my lord.
It's not saying you can't use site conditions, which would have the effect of limiting more than might be set out in the planning permission, the number of caravans. Because in this particular case, because it was unlimited, deemed unlimited, theoretically they had permission for 78. When I say theoretically, they had permission, didn't they? In other words, it was unlimited. You could put 78 on the site, so it was as though they had planning permission for 78 caravans.
Yes,
And yet that was limited to 24 by use of the site licensing regime.
You have a restriction. What you can't do, my lord, is to seek to nullify the permission itself by cutting the number down to extremely low level, and that's the point which...
Well, sorry, that's not decided by the case. That was common ground. It's not part of the ratio.
But it comes to the...
And in any event, if you think about it, how could it be ratio? Because if you want to have 4 enormous pitches for super caravans, you may not be able to get 60 of them on the site. You may only be able to get 4 or 10, but that's not nullifying the permission. It's all referable to the way you decide to build it out.
My lord, the size of a caravan, in terms of its maximum size, is limited. It's defined both by something which can be movable or in respect of a twin unit, so a caravan comprising 2 parts. The dimensions of that.
I took an extreme example, but maybe trying to get 60 twin units onto this site is just not feasible, even complying with all the other conditions of the 1966 permission. In other words, it's not saying 60 of any sort. Anyway.
Yeah, my lord, the permission is, to go back over ground at great length, but the permission is saying 60 of any sort. In terms of a caravan site licence, it will deal with, amongst other matters, the separation distances you need between those and the amenity. And the scheme which we had put forward comprised less than 60, to I think it's 30 A's and B's, so 36 caravans. But the starting point is that the planning permission has been granted. What the authority can't do is use the site licensing process to simply undo that because of a view on what the planning merits are.
Well, if they're purely planning.
Now,
And put the Airedale point another way, it would be very difficult to shoehorn Greenbelt policy into Section 5 of the 1960 Act. Whereas on the other hand, off-site transport effects could be related to Section 5 conditions.
yes, my lord, that's the way that's put, and the point is followed through in the Court of Appeal's decision in Babbage. Maybe helpful for us to turn that up. And my lords, that is in the authorities bundle at page 74. In terms of the extract I wanted to pick up, and that is concerned with, it's a case that starts at page 67. It's concerned.
What is it that you say we take from Estelle?
What we should particularly take from Babbage, my lord, is we find bottom page 74. Which is that a caravan site licence condition.
Sorry, what page are you on again?
Page 74 of the
Yes.
authority bundle, my lord.
Yes,
Page 255 of the report.
yes.
And the end of the last large paragraph there, where Lord Justice Fox says there's nothing in the case stated to suggest that the caravan any reason to impose the condition except to improve the aspect for the benefit of persons occupying or using other land. That seems to me to be solely a planning consideration, preventing the use of the site for the siting caravan solely for the benefit of the visual amenities of other land. And so that's in the impermissible category. And it's a point which, in the context we have here of importance, that the planning objection to this development is concerned very much with the heritage impacts, the World Heritage Site, which is outside the site, and views from across the valley, from one side of the World Heritage Site buffer zone into the other. And then the final authority I wanted to pick up, I've mentioned the skeleton. Go to the final authority to pick
This
up.
was a case where the issue was whether the site licence could impose a condition requiring the taking off the caravans from the site from November to March each year.
Yes, sir.
And that was not in the permission.
Not in
And
the.
effectively, there was no Section 5 reason for imposing the condition.
Yes, my lord, that's right. And particularly that visual amenity rationale was impermissible. Give my lord to authority, which is the decision of my lord in Shave, and that starts at page page 312 of the authorities bundle.
Yes.
And in particular, to go please to page 326. Where there's discussion by my lord of the Esdale and Babbage cases. And where my lord made the point at the end of 54, similarly planning policies would appear to be immaterial to the licensing function under the 1960 Act. I think it's an extract which both parties are referred to, and my lord's summary between 53 and 55 of the provisions is one that's agreed by both parties, I think.
This was a case where the challenge was the grant of a planning permission,
Yes, it was challenged to the planning commission.
and the members had been advised they couldn't take site design considerations into account because that was really a matter for site licensing.
Yes.
So it's really the other way around.
Yeah. Mm.
So that's what I had to decide.
Yeah.
How much of what I said is relevant to that, I leave others to.
Yes.
Yeah. So that's what I wanted to pick up on those authorities. Just the final matter of the authorities to pick up is the decision which the court helpfully referred us to in Crittenden, which I hope just
Nope. Not me. You got it? You got spares? Have you got the quarter session one too?
yeah.
I haven't, no.
Yeah.
Because it said my printer went. No, don't worry. Have you got the quarter session authority as well?
In cartilage.
Yes.
Yes.
Have you got copies of those, both of them,
Yeah.
for us while you're handing them up, please?
So I've got these are 3 copies of Crittenden. Apologies, it was.
Thank you very much. There's another one. Sorry, have you got the cartridge?
Just trying to put you on another copy of cartridge.
Thank you.
Two have been stapled together. So 3 copies of cartridge. Apologies for not having had that punched.
Don't worry.
So
Thank you very much. Thank you. Yes.
my lord, in Crittenden, the issue was whether a situation where the planning permission was for 13 caravans, by condition limited to 13, whether a site licence could be issued for more than 13, and the view of the majority, both agreed that the appeal against the site licence limit to 13 would have failed. The view of Lord Parker and Mr Justice Wynne was that taking the planning permission as required by section 3.3 of the 1960 Act, you look at that planning permission including its conditions and restriction. It's dealt with, it's summarised at the head note, the bottom of the first page and over onto the second. And then Justice Ashworth sort of concurred in the result, but he'd taken the view that, well, there could be conflict within this situation. There's no prospect of finding it unduly burdensome to have the 13.
To summarise,
yeah,
the majority went for section 29(4), which is an interpretation provision saying that planning permission includes conditions. They said explicitly that doesn't say that you cannot go against the conditions of the planning permission, but by implication that's where we get to. And Mr Justice Ashworth wasn't prepared to adopt that construction argument, but in terms of the policy of the Act, he got to the same outcome.
that
You would expect there to be consistency between the site licence. You wouldn't expect it to enlarge the planning permission.
Yes, my lord. And I'm not in these proceedings seeking to disturb Crittenden. As the analysis of the court goes, it recognises that there could be a different approach, but took the view that the site licensing regime it comes out of the planning process. And just for the note,
As far as Justice Ashworth is concerned, is that page 159?
yes,
He says the two should operate in harmony, not in conflict.
yes, that's right, my lord. And it's worth just sort of noting that there's some discussion of Crittenden in Esdell, and just for the court's note rather than turning it up. Mr. Justice Sachs in the High Court in Esdell, which is page 154 of the authorities, page 908 of the report. Crittenden go no further than the inability for site licensing conditions to differ on the same subject matter. There's then an explanation of Crittenden by Lord Justice Wynne in the Court of Appeal, and that's obviously one of the judges in the divisional court, and that is at the authorities bundle at page 183, page 937 of the report. And essentially his position was that the site licensing conditions confined to section 5 may not extend the use or be restrictive, nor be restrictive of it other than what section 5 authorises or for those interests. So it's not an expansion that's possible. So my Lord Crittenden's then taken into account in the cases that follow. I'll just pick up the inner house decision in Cartledge. That's a case which really turns on what the planning permission meant, and the court took the view that the planning permission, because it was granted in accordance with the plan, didn't grant permission for caravans to be sited on one part of the site, which was shown as mixed trees and undergrowth. There's seen, my lords, we know arguments as whether or not it would be a material change of use to put more caravans on the site. It's a case of really turns on the planning permission position, doesn't take us further in understanding caravan site licensing.
Except when you go to paragraph 21, the Inner House disagrees with the dictum of Lord Denning and Estelle, the effect that the planning authority should only concern itself with the question of whether the site should be developed at all, and should leave matters such as the number of caravans to the site licensing authority.
Yes, my lord. And Lord Denning's suggestion.
And I think he's the only judge in Esdale who said that. Is that right?
He was, my lord, and Lord.
I can't see anything following that subsequently.
No, and my Lord Denning's suggestion was, my lordships, was that the planning authority should just grant a planning permission, essentially in an outline of the principle.
But again, that isn't followed, is it, in practice?
It's not followed. It's not followed at all in practice, my lord, no. Because clearly there are some planning permissions which are very, very broad indeed. There are some planning permissions, and we have two examples before the court, which will have numbers in and will have particular things that can't be allowed.
The detail on the planning permission will be affected by the nature of the location of the site, the need, the extent of the control that is needed.
And some.
In actual fact, there's the Denning dictum is really, like, taking this short, is very surprising, because if you can't take into account purely planning matters under site licensing, and you've got a caravan site in a national park, what Denning is saying is you can't control the numbers in the planning regime, and there'd be a hole.
Yeah, and that has.
I'll be right.
Well, I must, my lord, it has the consequence, of course, that the planning regime is democratic in the sense that there is very much built-in public participation and so on. The site licensing regime doesn't have that element to it, so one might think that a lot of the big issues are ones to be best resolved in the planning regime. And as
so, when the Inner House disagrees with Lord Denning in 21, you wouldn't dissociate.
No, my lord, and Lord Denning's dicta is one which is simply never been followed in practice. Is the fair way of putting it. My lord, that is what I wanted to say on.
Yes, but there's also 22 in because this seems to echo what's said in Britain, very much starting with. The planning permissions are sine qua non of the grant of site license. Again, you can't enlarge the planning permission. So, is it fair to say that what we see in both Crittenden and in Partridge, looking at the other side of the coin, if you like, widening the scope of the planning permission as opposed to restricting it, see Esdale, is in all these cases regarded as being had to the planning position as a material consideration, rather than saying no, we've got to disregard it completely.
It's regard to the planning position in terms of the planning consent, rather than necessarily, one might say, the current view on the planning merits. And that distinction is an important one, because what Crittenden is using the planning permission which has actually been granted as the anchor for the site licensing decision, which then follows on from that. What it is not doing is allowing a revisiting of the planning merits which have been determined by the site licensing
Can I ask a very simple question? What this case was all about in the FTT and UT was about a proposal on your client's part to retain a certain number of existing hard standings, not all of them, but a certain number.
It was a well, my lord, it was a
Secondly,
proposal. So it was
yes.
a proposal.
That's what was on the table
Yeah.
to be considered. Secondly, to be able to obtain a licence to that effect, you were going to need a planning permission for those hard standings, which is why the permitted development rights issue arose.
Yes, my lord. What we were seeking to do was to get in terms of the scheme that was put forward.
Put it this way, the licence when granted, it identifies the planning permission, which is the sine qua non for the grant of the licence, doesn't it? All of them do.
Yes, my lord. Yeah.
Well, if you'd been successful, your licence wouldn't have referred to the 1966 permission, or at least not by itself. It would have to rely on the PD rights.
No, my lord. The licence would refer to the underlying permission, not
For the use.
for the refers to underlying permission simply as a I say an anchor for the
But
licence.
critical to your case, as I understand it, tell me if I'm wrong, is you needed to show that you could rely on the PD rights.
Not, my lord, not in the site licence application. The site licence, the effect of the site licence application would be to grant PD, would be to
Well, yes,
for there to be PD rights.
Cart before the horse.
In the enforcement case, we didn't have PD rights, as the inspector found, because we put down bases and infrastructure which didn't accord with the 1968 site licence conditions. So that's why the enforcement notice appeal failed. What we're seeking to do is to use this site as planning permission for 60 caravans in an updated and modern fashion and make the beneficial use of what has been approved and been in place for a very long time. To do that, we need a site license. The concept in terms of
basically, you're asking for a site license which has that effect without the benefit of a pre-existing planning permission for those hard standings. And secondly, your legal argument is that it's an immaterial consideration. It's irrelevant that planning permission does not exist.
my lord, we apply for the planning permission for the hard standings would arise from.
Yeah, I heard that.
So,
I understand. I really have grasped that. That's a consequence of being successful in the appeal on the site licence. But in order to be successful on the appeal of the site licence, unless I'm misunderstanding things, your argument depends on saying that the fact that the enforcement notice decision appeal went the way it did should be disregarded. It's irrelevant. Because if it's relevant...
Yeah, the enforcement notice appeal doesn't arise because the reasons which we lost were that we weren't in accordance with the 68 site licence. That point doesn't arise on a new site licence.
Exactly, it's an irrelevant consideration.
Yeah, and the pure planning merits, which is the way in which the Upper Tribunal looks at the view that what is proposed on the site is presently unacceptable in planning terms. That is an irrelevant way of addressing it, because what I'll turn to the Upper Tribunal decision very shortly.
I think you need to. It's 20-1, so I'm a bit worried about the time.
Yeah. The Upper Tribunal decision is one which is enforcing or giving effect to, in the tribunal's view, the view on the planning merits at the present time of a caravan site with hard standings and the like that followed.
Right.
Yeah. Can I pick up then very quickly some aspects of the first tier tribunal decision, just to be, so we have in mind what is the basis of the evidence in terms of plots in and plots out.
Yes.
So, my lord, we go to core bundle 80.
Yes.
And paragraph 69, Mr. Arkle is the head of housing and growth for the council, their main witness at the in the first tier tribunal. He was saying at 69 that he was assessing which plots could be permitted under the licence and not conflict with the tree replacement notice, or which could be required to comply with the operation development notice. What he then explained, page 81 of the report, paragraph 7 of the decision, paragraph 73, Mr. Arkle accepted that 3 plots allowed to remain in the licence were on land subject to the enforcement notice. He thought it was reasonable for those plots to remain, as he thought reprofiling the sites required by the notice would not in fact affect those plots. And that's his explanation for 1, 23 and 24. He then accepted in his evidence that other plots would not be affected by reprofiling the site. So there's another 5 that go in there. And then in 74, plots not affected by the TRN. So the council's position wasn't that anything that had to be removed by the enforcement notice, which Planning Commission had been refusing the enforcement notice appeal, was not able to be in the site licence. Allowed 3 in and then accepted that the same rationale applied at least.
Those 3 plots, did they have hard standing on them?
They did, my lord, yes. And
So logically, the mere fact that they didn't need reprofiling didn't actually address that bit of the enforcement notice, which required the hard standing to be taken away. Is that the point?
well, yes. The concern on reprofiling was that a lot of the site is heavily sloping, so the plots are there's a degree of levelling out to do that. And Mr. Arkle was saying, well, some don't need that levelling out to be done. That changed the levels, and those 3 he accepted into a problem, and then he accepted that in respect to another 5. And the first tier.
Were the other 5 affected by the tree argument?
They weren't affected by the trees,
Okay.
because we can see just back in paragraph 73 and 74, my lord.
Yes, thank you.
And there were a number which
Some were.
number which Mr. Arkle thought were affected by his reprofiling argument, but not affected by the trees.
Thank you.
And just won't take the court through it, but just for the court's note, the first tier tribunal reasoning was that it was reasonable to fix locations, but that's not in the model standards, and that's at paragraph 133 to 136. The limit to 3 caravans is unduly burdensome. That's paragraph 137, 157. And they then look at the impact of the enforcement notice from paragraph 140 onwards, and draw a distinction between the enforcement notice looking backwards and site licence looking forwards, and then they did their reasoning on the trees is from 148 onwards. And my lord, our position is that the first tier tribunal was one which they were
Sorry, they were-
entitled. the first tier tribunal decision was one they were lawfully entitled to reach. I turn then to the Upper Tribunal decision, and what I'll do is go through the critical parts of their reasoning and make my submissions on those whilst I'm doing that.
My recollection is in the Upper Tribunal it's a rehearing. Isn't it? Have you considered that?
Well, it wasn't. Right, I think I know what I'm not sure. Because the
At least some of the
approach
Upper
was
Stands Chambers jurisdiction as a rehearing. This wasn't run as a rehearing.
there was no further
Forget
evidence,
that.
my lord. It was simply submissions on that, and the Upper Tribunal's reasoning was based on irrationality,
Yeah.
a public law
I
finding.
understand.
There's a lot of said for deferring to the judgment of the first tier tribunal. I think it's in the magistrates' court cases as well, in terms of what view they take on the unduly burdensome matters on the merits. If I can go, my lords, to the Upper Tribunal decision at paragraph 47, which is page 53 of the bundle. My learned friend Mr. Kimberley referred to a planning case called PowerGen. That is, my lord, a different situation. It was a rationality challenge. The local highway authority had turned up with a planning inquiry resisting highways measures in respect of a scheme. The inspector had rejected the highway authority's case, and the highway authority then refused to enter into an agreement with the developer to allow those measures to be carried out. And the court considered that it was irrational in public law terms for the highway authority to refuse to carry out something which the planning inspector had said was perfectly permissible, and had rejected the highway authority's arguments. That's in that particular situation. Paragraph 48, and this point is also made at 54 and 55, is the view of the Upper Tribunal that there is what it puts as a paradox, which is, we are said to have said, pure plan considerations, we did put as a paradox, of course, are said to be irrelevant to the terms which a licence can be granted, yet the grant of the licence will carry permitted development rights without the planning consequences of those rights being assessed as part of the licensing process. My lords, that is not a paradox. It's very much the way which the process works. So planning permission, we picked up in Esdale and Babbage, that there would be a planning permission or the use of the site allowed to become lawful. There would be considerations in the planning process, Esdale, Greenbelt, Babbage, visual effects for those who are simply off-site, which it's for the planning process to control, not site licensing. A consequence, let's say those cases don't deal with the PD rights, a consequence of the site license would be that permitted development rights would arise for certain works which may well have planning impacts on the greenbelt and on visual amenity of pure planning considerations. So, for example, if you have hard standings, that would mean that caravans can be there in practice sited year round. Utilities blocks in the old days, they would tend to be toilets and shower blocks. Now it's sort of simply putting in services. Those sorts of matters are matters which would have impacts in the appropriate case on greenbelt or on visual impacts So it's not a paradox that the site licensing system gives rise to development which may have planning consequences, and in this context, pure planning consequences, that the site licensing authority, just stepping out of the facts of this case, the site licensing authority, taking into account the site consideration, may require physical works to be carried out, which would have, may now be seen as a harmful effect in pure planning considerations, matters the site licensing authority can't consider, but matters which the planning authority would consider and might be very concerned about. The mechanism for dealing with those in the legislation is not for the site licensing authority to apply those pure planning considerations, but it is firstly for the planning authority on originally granting planning permission, if it's done that, to deal with those and then live by the consequences. And if it, in due course, considers the consequences are unacceptable, then the planning regime has the mechanisms for doing so, discontinuing the planning permission or modifying it by discontinuance, or removing the permitted development rights by an Article 4 direction.
Sorry, which planning permission are you talking about would be discontinued? I understand your point about PD rights. but
PD rights.
What about the first alternative? How does that apply here?
If the authority was to take the view that it's quite unacceptable to have 60 caravans or anything like that because of pure planning considerations, which in this context would include the impact on the World Heritage Site, then the way of dealing with that would be to make a discontinuance order in respect of the 1966 permission.
In the enforcement notice appeal, did your client rely upon the 1966 planning permission at all, as opposed to just PD rights?
Not in respect of the operational development, because 66 permission doesn't grant planning permission for operational development, it grants planning permission for the use. So we didn't on the operational development, obviously did on the use notice appeal and the Clopwood appeal.
Did it require hard standings? I can't remember.
The 66 permission doesn't. I may be helpful, my lord, just for us to...
It does. It controls location, but didn't require hard standings. Okay.
Yes, it has the layout and has a number of other restrictions, but it doesn't approve our standing. That was left to the PD rights pursuant to the site licence process.
Thank you.
So, my lords, in terms of looking at whether the first tier tribunal decision was rational, it is necessary to look at the decision making in the context of the site licensing regime and the planning regime. And if there is a concern about the planning impacts as opposed to a matter that is legitimately within the site licensing regime, then the site license conditions can't be used to address that. Yet that is what the approach which the first tier tribunal took in finding that the FTT had actually rational, because when it comes down to it, what the first tier tribunal are saying is that sorry, what the Upper Tribunal, apologise, are saying is that the site licence would lead to, as we were seeking and the FTT proposed, approved, would lead to a outcome which was inconsistent with the outcome on the enforcement notice appeal. So that is, my lords, taking the pure and so irrelevant planning considerations at its extreme point. It wasn't the Upper Tribunal rationalising that as saying, well, in terms of legitimate site considerations, then it can be, then we can limit it down to 6 caravans. It was seeking to apply a view on, ultimately on the planning merits, which the enforcement notice decision encompasses, a view on the planning merits in the site licensing process, and saying, well, you can't undermine that planning merits decision about what's appropriate in the 2020s by a site license which has PD rights, which will allow development there. That is an approach which is quite impermissible. It doesn't fall within Section 5.
Why do you say that what the UT is doing is taking account of the planning merits viewed in today's
Because
perception? I mean,
yeah.
as I read the UT's decision, it's premised on the inconsistency with the enforcement notice, and the enforcement notice is not about, is this a good development to have in the buffer zone of the World Heritage Site, but are the hard standings in the positions permitted by the planning permission back in the 1960s? And the answer is no. That's why they're not permitted development. Have I misunderstood that?
My lord, the enforcement notice decision and the appeal, the inspector's decision on that, has one essentially two elements. One is, were the works carried out lawful? Did they have permitted development rights? The inspector finds they didn't have permitted development rights, not in fact on the basis of the 66 permission, but on the basis of the 68 site licence layout, that it was inconsistent with that. So that's why there aren't permitted development rights. The second aspect of the enforcement notice decision is, should planning permission
Now be granted.
be granted?
And the answer is no.
And the answer was no, on the basis that the inspector considered that the planning merits, this
Yes, but
planning merits were acceptable.
but the UT is not saying that the site licensing authority should form its own view on the planning merits or take into account planning considerations. All it's saying is the site licensing authority should produce a result which is consistent with the planning position. And the planning position at the moment is you don't have permission to put in the hard standings you put in because they're not in the position permitted in 1968 and no new permission has been granted for them. That's not the site licensing authority taking its own view of planning merits, is it?
Well, quite, because what the Upper Tribunal is saying is that the first tier tribunal essentially bound, because it was irrational in public law terms, not to give effect to the view in the enforcement notice. And that view, my lord, is a planning merits view.
Yes,
because
but the reason that the Upper Tribunal says that the FTT shouldn't have done that is not because it was open to the FTT to take account of what it thought of the merit, the planning merits, but because it should produce the licence regime, should produce a licence consistent with what the planning regime has produced. And what the planning regime has produced is although you have permission dating from 1966 to have caravans on the site, the hard standings are not permitted development. They're not permitted because they're not permitted by the 68 licence, and they're not permitted under a new permission because the inspectors decided that no new permission should be granted. So the hard standings are, in planning terms, in breach of planning control. And all that the UT is saying is, well, the site licensing authority should do something consistent with that, not something that's flatly inconsistent with it. Isn't that?
Well, what it's doing is applying a pure planning considerations, a fair way of describing it, in a way that the tribunal is doing. The first tier tribunal is bound by that position. Now, that is not what the legislation allows. The first tier tribunal.
Why not? This is what I'm having difficulty with. You showed us in the 1960 Act, you can't grant a site licence to someone unless they have planning permission. In other words, the planning permission is a pre-condition of getting a site licence.
Indeed.
Well, why is not planning permission to keep your hard standings in place, which you don't have and you've been told to take them away, a precondition of getting a site licence to keep the hard standings in place?
Because, my lord, that is, if I may say, flipping it the wrong way around. A planning permission, which we do have, is for the use.
60 caravans in particular places,
But
but not in other places.
it comes to the layout point in due course. I know there would be after lunch, but to just deal with this point, the planning permission is for the use. Just to go back to the way the system operates, planning permission for the use, it may well approve operational development, it may limit it, or whatever. The site license will say what facilities need to be on site, including whether there's a need for hard standing, roadways, and like. The permitted development rights will arise because of that. So it's not my lord.
I've understood that,
Yeah.
but you don't have them at the moment.
Yeah. Of course we don't have that at the moment. That's why one of the things we need with having a site license. But the fact that when a site license is granted, you don't, prior to that point, as the operator, have planning permission for the hard standing and everything that's required by the site license, which is the essence of the point of the enforcement notice, is irrelevant, because what the site license and the permitted development rights are there to do is to then give you planning permission for those physical works which the site license is requiring.
Now, normally, Mr. Howard, PD rights are granted by Parliament for development which it thinks doesn't expressly require planning permission. It doesn't require to go through a planning committee, for example, or a review.
Yeah.
But the effect of your argument is, no matter what the scale of development required by conditions in the site licence, you automatically get the benefit of the PD rights without the planning merits of that development being considered, because pure planning considerations won't be capable of being taken into account in the site licence. That's what Parliament has done by creating this particular PD right.
Yes, my lord. So, and subject to two caveats, given my lord's point about scale, which is that all permitted development rights are subject to a requirement for environmental impact assessment screening if they go over the thresholds which EIA may be required. My lord, that's Article 10.10. And
to that,
if they may have a likely significant effect on a European habitat site, there's a separate regime there. But yes, my lord, Parliament has made that decision that going, perhaps the final point I can make before lunch, the decision that the way the caravan system would work is, firstly, there should be planning permission that may restrict, it may allow, it may grant permission for particular bits, whatever. Then a site licence is secured. The works which are required by the site licence are permitted development. It's within that confine. if the authority then has a problem with what it ends up with, having gone through multiple stages, then it still does have remedies. It can take those permitted development rights away.
Right. How much longer?
My lord, I would have thought sort of 15 to 20 minutes.
Okay, would that leave you enough time?
You-
My lord, it will.
Okay, thank you very much. I'll start again at 2 o'clock.
All rise in favour.